Good afternoon, and thanks for joining our October Data Practices Potpourri webinar. We are happy you are here. For those of you who aren't familiar with us, the Data Practices Office is a small office at the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and the government, and we encourage you to reach out to us with any questions that you might have. We help the Commissioner with issuing advisory opinions, and we also provide legislative assistance and training. Our webinars are recorded, so if you missed part of today's webinar or want to go back and watch one of our prior series or share one with a friend, they are posted on the Data Practices Office YouTube page. I'll show you how to find those videos on our website, which is the link on this slide. So this is our website, and you can see here on any page in the footer, you will be able to find the YouTube link on the Connect With Us portion. We also have a lot of information on data practices, the open meeting law. All 1,000 plus of the advisory opinions are in the opinion library here. And then under news and events, I want to point out under workshops, we are now hosting remote paid workshops, and we have a law enforcement data one coming up on November 10th, and we still have some space available, and you can register for that on this page. Also under news and events, you can find the webinars page, which is where you registered for today's webinar. And here you can find a lot of information. You can find some slides from the previous webinars. You can find a link to our YouTube channel. If you are ever experiencing audio issues, there are some audio FAQs here as well. If we go to our YouTube page, you can see there are a lot of videos, not just our webinars, on our page. If you go to playlists, you'll find the webinars, and you can see previous series on the open meeting law, personnel data, and law enforcement data. And then today's webinar will also be recorded, and in the next couple days, it will show up here under Data Practices Potpourri. If you would like to download a copy of today's PowerPoint, I'm sharing the file right now. A pop-up will show up, and you can select the PowerPoint and download it to your device. Today is the second installment of the Data Practices Potpourri, which is an opportunity to hear what issues data requesters and government entities encountered this month. As usual, we'll leave some time for questions at the end of the webinar. Feel free to send in your questions as you think of them at any time. Make sure you send them to all panelists so that we can be sure to see them. I'll put up the file again to download the PowerPoint at the end if you missed it this time around. So question number 1, does a government entity need to report a data breach to the Data Practices Office? We had a number of questions about data breaches this month from both members of the public and government. The answer to this question is no. Section 13.055 does not contain any requirement to contact the Data Practices Office if an entity has a suspected data breach. Entities must make the determination as to whether a breach has occurred and whether the subsequent required steps are necessary, and those might include notification, investigation, public report, or credit monitoring. As always, we're happy to discuss issues around breaches and the classification of data, because in order for 13055 to apply, the data at issue must be private or confidential data on individuals. Ultimately, our office and the Commissioner are somewhat limited in terms of making the determination of whether a breach has occurred. Entities are in the best position to determine who had access and whether the person that had access also had the requisite intent to use the data for non-governmental purposes. Question 2. Can entities ask requesters for prepayment for copies? What if the requester then asks to inspect? Answer: entities may ask for prepayment and should include that in their access policies. Data requesters may change their minds and choose to inspect rather than obtain copies. An inspection is always free. You can look at Minnesota statutes section 13.03 and 13.04 for more information about that. One of the specific questions we received this month was if the entity had to refund the prepayment because the data requester ultimately decided to inspect only. And the answer to that would be yes, because inspection is always free. We receive a lot of questions about property complaints each month, and this month was no different, and how to classify those data in complaints. So question 3 is, a requester asks for all police reports about his apartment for the last year. Most of the calls are noise complaints by a neighbor. How are those reports classified? The reports could include both public and not public data. Most data in police reports are public under 1382 or the general presumption. However, the following data are confidential. The identity of an individual who complains about the violations of state laws or local ordinances concerning the use of real property. Those identities are confidential. So here, if there's a local ordinance or state law about noise levels, which often there is, then the complainant's identity is confidential and needs to be redacted per section 13.44. Remember that identity is more than a name. A lot of these types of complaints occur between neighbors. So if the substance of the complaint identifies the complainant because, for example, the complainant references banging on their kitchen wall and they only share a wall with the data requester, then the information should be removed from the report under 1344 because it would identify the complainant. But the other information on the report about the time of the complaint, who received it at the police department, who responded, etc., are all public. Now, if the complaint is about the use of real property, but there isn't a law or ordinance about the behavior, then the complainant's ID is not confidential under 1344. It's just public. So each of those 3 things need to be present in order for 1344 to apply. What is the classification of a data request? The lawyer's answer, it depends. If the request is by a member of the public for public data, then the request is public, including any contact information provided by the requester. If the request is from a data subject, then the request may be public or private depending on the classification of the data requested. So a couple examples of private data requests. A public employee asks for copies of his or her performance evaluations. Under Section 1343, data about public employees are private unless they're listed in Subdivision 2, and data requests about their own data is not listed under Subdivision 2, so those requests would be private. Similarly, client receiving social services asks for copies of their file. 1346 makes data about clients receiving social services private, and so that data request would also be private. An example of a data subject request that is public would be if someone asks for data about themselves in correspondence with the Data Practices Office. We don't have a classification for that type of data, so both the request and the underlying data would be presumptively public, even though it's a data subject request. A related question that we receive is, what is the classification of a log of data requests that a government entity maintains? The data in the log will determine the classification. So again, if the log identifies a person asking for their own data about the social services they receive, that part of the log is private. If you cannot identify any private data from the log, then the data on the log is presumptively public. Entities do not have to create a log of data requests, but if they do and they maintain it, they should just be mindful of the classification of the data in the log. Question 5, this is a personnel data question that we received. In response to a complaint and investigation, a county has decided to terminate an employee. The employee is exercising his right to a veteran's preference hearing, but did not elect to grieve the termination under a collective bargaining agreement. Can the county say that the employee has been disciplined? Yes. The following complaint-related data are public: existence and status of any complaint, the final disposition of disciplinary action, data documenting the basis of the action, and specific reasons for the action, and that is under 1343, subdivisions 2A and 2B. Final disposition occurs when the employer makes its final decision, quote, regardless of the possibility of any later proceedings or court proceedings. So this would include a veteran's preference hearing. The legislature specifically added the language about later proceedings in response to a Minnesota Supreme Court case that raised this very issue, where a disciplined employee elected a veteran's preference hearing, and based on the previous language, the court held that the decision wasn't final until after the veteran's preference hearing. So the legislature remedied that by adding this language, regardless of the possibility of any later proceedings or court proceedings. So here there was a final disposition of disciplinary action once the county made its decision to terminate. In the scenario in this question, if the employee had elected to grieve the termination under a collective bargaining agreement, final disposition would not have occurred until the conclusion of the arbitration process. And that is also under Section 1343, Subdivision 2B. We had a few questions about summary data this month. What is summary data, and does a government entity have to create it? Answer: summary data means statistical reports, records, and reports derived from private or confidential data on individuals in which individuals cannot be identified. And that definition comes from 1302 Subdivision 19 and Minnesota Rules 1205.0200 Subpart 16. So in general, government does not need to create data to respond to requests. The exception to this rule is summary data. Government is obligated to create summary data when the requester requests it in writing and pays for the cost of preparing it. Government can also enter into an agreement with another party, including the requester, to create summary data. More guidance on summary data, what it is, how to create it, can be found in Minnesota Rules 1205.0700. Note that requesters might be asking for summary data, but they might not be using that particular phrase. So government entities should look to the request to determine its obligations, whether the request is asking for summary data. How should an entity provide for inspection during the COVID-19 pandemic? We know that there are some entities or offices within entities that are fully open and operating mostly as usual. And for those entities, they should continue to provide access as usual, plus masks and social distancing. We also know that there are many entities functioning remotely right now, and that has made responding to requests challenging, particularly for requests for inspection. There aren't any one-size-fits-all solutions to this challenge. A lot will depend on IT capabilities and then each entity's guidelines around engaging with the public. The requirement to provide inspection continues during the COVID-19 emergency, and for some of us working from home, we will continue to do so well into 2021. So we need to come up with some strategies to provide access to data. We have heard of some entities experimenting with virtual inspection via video conferencing. There are some applications that will even allow requesters to scroll through the data themselves. We have also heard of others using locked shared drives where requesters can see the data. And in both of those instances, the requesters could still take pictures just as they would be able to during an in-person inspection. Entities might also consider partnering with other programs or offices within their entities that might be open to the public. And then, of course, entities can always provide copies in lieu of inspection for free. You are not required to provide data for free, but that is one of the ways to provide free access in lieu of inspection. If anyone listening has ideas about how to do inspection during this time, please feel free to share them with us in the survey after the webinar or send them to us in the Q&A panel. There is a COVID-19 resource page on the Data Practices Office website, and if we get some additional ideas on inspection, we can definitely share them there. And here's the bonus question. When will the 2020 Data Practices Laws and Rules book come out, and where can I get it? For those of you who have been to one of our workshops, you might recall receiving one of these statute books, and someone recently asked where you could get a copy of the most recent one. Unfortunately, the bookstore will no longer be publishing the statute books, so like so many things, we all have to transition online and use the reviser's website or another online resource. So those were some of our top questions this month. I'm going to put up the PowerPoint again. We have time for questions, so if you haven't already, please feel free to put them in the Q&A panel to all panelists. If we don't get to yours during the webinar, we will definitely follow up with you.
Okay, so it looks like we have a couple questions already. The first question is, what would be the data classification of a pending veterans preference hearing? I'm not sure if this is referring to personal data as the entity, but once the entity has made their final decision, if there was discipline, the data documenting the basis for the discipline is public regardless of a later veterans preference hearing. So while the hearing's pending, the data at the entity that documents the basis for the discipline are public. Next question, is there a particular document to use for summary data? No, there's not one document or form that entities should or must use. There's also not one particular form for the public to request summary data. Entities might have specific procedures for requesting summary data and its own access policy stuff. So that would be a good place to start. Here's a question regarding law enforcement data. Regarding police reports, if the police are called for a welfare check of a person having a medical or mental health issue, there's no arrest, is there anything that protects the person's identity and medical information? There is not anything that protects the medical information, except for there's one protected identity that protects the caller in a mental health emergency. So the caller who reached out for assistance, their identity was protected, but sometimes that's not the person who's experiencing the mental health emergency whose data would be presumptively public. Here's a question. Is the investigation file leading to final disposition of discipline of a government employee ever subject to data requests? So data subjects, they can have access to their own private data. Much of the information in the investigation file will likely be about the employee, and so they have access to their own data about them. If there's data in the investigation file that documents the basis for the discipline, then that would be subject to a public data request as well. So data subjects can have the data about themselves, and then if there's public data that documents the basis for discipline, that would be available to members of the public as well. Please feel free to keep sending in your questions. I'm just reviewing to see if there's any that are still pending.
So we have one question that says, if an entity receives a court order for records and there still exist paper files and closed records on the data subject that should have been destroyed months prior, but due to COVID was not, is the entity obliged to provide the data? So there's a couple parts to that question. In general, if you get a court order for records, you're going to want to provide that to your legal counsel and have your legal counsel advise on what's responsive to that court order. But and the second part is, in general, if you have data that could have been destroyed and now it's being requested, whether in a court order or a data request, if you still have it, you have the obligation to provide it. Just because you could have destroyed it doesn't mean you should go ahead and do that really quickly now that you've gotten a request for it.
There's a question, can a person who sends an email to a state agency regarding a violation of an executive order request anonymity? Can the agency redact the email sender's name? So it's like presumptively public unless there's a specific classification that would protect complaints regarding that particular executive order. Some complaints could relate to property violations, so that might be something to consider. But generally, a person can't just request anonymity from the government. There has to be an actual classification in the statute that would protect that person's identity. There's a question about data requests from public defenders. When a public defender makes data requests to a government entity, there is a provision that says that when public defenders are acting in their capacity as a public defender and request data from a government entity, they can't be charged. The question also relates to when they submit their request through discovery. That discovery process is separate from data practices. And so however the court manages that discovery process falls outside of the data practices. But as far as this data practices request from a public defender, they can't be charged for copies when they're requesting in their capacity as a public defender.
We have a question that says, can you talk about the classification of a written complaint against a council member in a statutory city where the council has taken no formal action to deem council members employees for purposes of the Data Practices Act? So generally there isn't a classification for data on elected officials. And so it is up to each entity to determine and decide whether or not their elected officials are employees for purposes of the Data Practices Act. And as such, any data that comes in or is collected and maintained about those public officials, elected officials, would be subject to Section 1343 protections. So if the city has to make the decision about whether or not their elected city council members are employees or not, and then the classification of the data will flow from there. If they are employees, then Section 1343 applies, and complaint data will depend on whether there's final discipline. If they're not employees for data practices purposes, then data that the city maintains about them is just presumptively public. Okay, so one quick follow-up that I missed. How about the names of employees who participated in the investigation? So again, we're talking about personnel investigations and what data in an investigation, maybe an investigative report, would be public. So if there's final discipline of disciplinary action, the data about the employee disciplined will be public if it documents the reason for the discipline and the basis for the discipline. Data about other public employees who are maybe witnesses or complainants is still classified under Section 1343, and so that data needs to be redacted either in response to a public data request or if the subject of the report asks for it.
There's a question that says, can a government entity use citizens groups to evaluate applicants during a job application process? So this is a process question, and whether you're allowed to do that when you're hiring a government employee is a question that falls outside the scope of data practices. It might be governed by union contracts or other employment law. Whether data can follow would be a different question. And if you decide to do that sort of process and you want to talk about what data could be shared, you can give us a call and I'd be happy to talk about that further. Okay, if anybody else has any other questions, feel free to send those in. Otherwise, we will wrap up. All right, so we'll close out for today. Our next webinar is going to be on December 1st. We're going to talk about the open meeting law during a pandemic and some additional open meeting law questions that we've had recently. So keep an eye out for that. If you'd like to attend our law enforcement workshop, you can register for that on our website as well. Please answer the question on the survey when you're closing out. We'd love to hear your feedback and if you have any other topics you'd like us to cover in the future.